it's that time of year. It's June, which means the Supreme Court is winding down their term, and it's time to start fixing a little bit of what the liberals have broken. Every year we see it happen. The liberals spend months and years destroying America and doing all sorts of dumb shit. And then in June, the Supreme Court nullifies some of it because they go, holy crap, that's really dumb. You really think we're going to let you do that? And here's an example of it. So several states across the country, I think over half, banned transgender affirming care for minors across a bunch of different laws, different government entities, a whole slew of stuff. And a lot of it started about a year ago, and it's been going on for the last 2-3 years. So in Tennessee, a bunch of minors and their parents, my guess is mostly the parents, decide to sue the state of Tennessee, saying that their laws preventing transgender affirming care for minors was unconstitutional. And what we're going to try to do here is we're going to try to explain why the Supreme Court said it wasn't unconstitutional and how they came about deciding that. So I've talked about before in the past how there are levels of scrutiny, and those levels of scrutiny come into play when the Supreme Court has to decide on the constitutionality of a law. Those levels are strict scrutiny, intermediate scrutiny, and rational basis review. So I'm going to break it down by each level. Strict scrutiny. The standard for strict scrutiny is the law must be narrowly tailored to achieve a compelling government interest using the least restrictive means possible. This is the most rigorous standard, and laws rarely survive strict scrutiny. And when the Supreme Court uses strict scrutiny, the government bears the burden of proof to show that it doesn't matter who sued who. The government bears the burden of proof under strict scrutiny to show that that is the best course of action to get there. So an example of this would be a state law banning interracial marriage. The courts would apply strict scrutiny because race is a suspect classification. Race is a protected class. So the government must prove there is a compelling state interest, like public safety or national security, and show that the law is narrowly tailored. Now, historically, laws like that fail because the Supreme Court can find no justification for not allowing the different races to marry each other. Now, there's intermediate scrutiny. The standard for intermediate scrutiny is that the law must be substantially related to an important government interest, and the government must demonstrate that the law directly advances a significant objective and is not overly broad or under-inclusive. So this standard is used when the Supreme Court is reviewing a law that might apply to what we call a quasi-suspect class, and that's a lower class than race, religion, or national origin. It's more closely related to gender or certain limited rights or commercial speech. An example of a law that would have to pass intermediate scrutiny is a federal policy providing different benefits to male and female military personnel based on their gender. Now, another example would be the insurance rates here in the United States. Now, we know that women get better insurance rates than men. And the Supreme Court has ruled that that is constitutional because there is an interest in making sure that A, everybody can receive car insurance, and B, that because men have more accidents, even though I believe the latest statistics show that men have, while they have more accidents, they're of a more minor nature, whereas women have less accidents, but theirs are usually much bigger. So the idea is that that allows for a balance between costs and everyone being able to afford car insurance. Now, finally, we get to rational basis review, and this is the lowest level of scrutiny. The standard here is that the law must be rationally related to a legitimate government interest. And here, the government only needs to show a reasonable connection between the law and a permissible goal. And here, the plaintiff, the challenger, would bear the burden of proof to show that the law is arbitrary or irrational. This is the level of scrutiny that the Supreme Court used here. The plaintiffs argue that they should have used the intermediate level of scrutiny because this is related to sex. But in his opinion, Roberts said that this is not an example of sex-based discrimination and more of an example of a government interest in making sure that children reach a certain age without having issues that are going to harm the government later. It's kind of funny to have to explain all this stuff in legalese when we should be able to just look at it and go, of course not. Maybe we don't cut off the testicles or the breasts of 13 and 14-year-old kids. Maybe we don't mutilate children. Maybe we tell children, hey, you know what? You think you're this? That's cool. But why don't you wait till you're 18, 19, or 20 when your brain has fully developed, or at least developed to the point that you can actually start making rational decisions? And then let's see what you have to say. Think of all the tomboys out there that we all grew up with that love to go jump in the streams and skip rocks and do all this stuff. Think of all the men that we know that spent time, that enjoyed going shopping and stuff like that. People change. People have different interests throughout their lives. Maybe then we could start getting back to a sense of normalcy in this country. Until then, as long as the Supreme Court is on watch, we can at least count on them to eliminate a little bit of the looniness and craziness that the left decides to push on our children and on the rest of the country. Peace out, guys.